which I guess is the proper segue into the overall update on the vaccine mandate lawsuits. What's the latest? I mean, the last time we discussed it, I forget what we were waiting on, but bottom line, a number of the religious objections had been maintained at the higher levels of court. What did we see in the last week?
So a split. So a federal court in the Eastern District of Tennessee enjoined a federal contractor from putting people on unpaid leave because on the grounds of religious accommodations. So this was another employer that was trying the Tyson approach of saying, okay, yes, we recognize you have a conscientious objection under religious protection laws from this vaccine. However, our accommodation is going to be, we're going to put you on unpaid leave for some period of time. And the only thing that changes by employer is what period of time they label that. So a federal court in the Eastern District of Tennessee issued a temporary restraining order while listening to the preliminary injunction. And the court just pointed out, you've been dealing with these accommodations for a year. You can't deal with them for 2 more weeks? You got to lay these people off right now before I can even hear the preliminary injunction? I don't think so. So I think the court enjoined them from doing so because there's national security clearance issues. Similarly, in I believe it's the Northern District of Texas, United, the federal court also temporarily restrained United in that context for the same reason, saying, look, these people suffering, having to take in a shot rather than lose their job puts them at imminent risk of imminent harm to their conscience and to their bodily autonomy. And so I'm going to prevent you from doing anything towards them until I hear the full preliminary injunction hearing. A court in New Mexico, federal court in New Mexico, and this will become part of a pattern, refused to issue an emergency injunction on similar grounds. A state court in Washington refused to issue an injunction on somewhat different grounds, but it's still related to the vaccine mandate issue. And then a federal court in Maine refused to even recognize a right to religious accommodation in the vaccine context. First court to do that. And the First Circuit refused to intervene. In that case, may be heading to the U.S. Supreme Court. And will pose a different question. Now, Justice Breyer is the gatekeeper for the First Circuit. My understanding of the normal protocol is they should refer it to the whole court. When they don't do it, in my experience, that's because they fear the whole court's going to reverse their opinion. So we'll see what Breyer does and what the court does with that, because this would be the first religious accommodation question in the U.S. Supreme Court context. Not surprising out of Maine. And what the pattern that's showing up, and then, of course, there was the case you covered, a family court in New York that gets all their news from MSNBC and CNN, busy libeling Joe Rogan in their spare time. Both those networks.
All subjects we're going to get to tonight. Robert, that judgment is over the top, right? I mean, there's no sanction that can come to that judge other than not being elected. Like, this is not egregious enough that, I don't know, whoever his supervising authorities are, say maybe you need to go to a seminar or two. Can that possibly happen?
It's the Family Court of New York, or whatever subdivision. I think they call it the Matrimonial Court. I didn't know they had another one like that. But the Family Court of New York is infamous for abusing people's constitutional liberties and rights. So I was the first lawyer to sue the Family Court of New York. On civil rights violations grounds for Wesley Snipes. And so while generally you can't sue a court, and they said we couldn't sue. We sued anyway, got the right attention, and they settled the case while the appeal was pending. And the West never appeared in that court until he'd won, and he only showed up to remind the court that they never should have done what they were trying to do in that case. And so it's not a surprise to me this comes out of the city of New York. What we're seeing is where are we seeing these crazy family court judgments? New York and Chicago. Where are we seeing denial of natural immunity? Places like California. Where are we seeing an unwillingness to get involved in the emergency injunction stage, even in religious injunction-related cases? Out of cases where the courts are sitting in Chicago or Seattle or San Francisco or L.A. or Boston or Portland, Maine. It's or New Mexico, Albuquerque. It's geography. It's where you're seeing the overtly political courts that believe in deferring to the public health authorities, particularly under the Biden administration. I think some of these courts would have been nowhere near as deferential if Trump was still president. Whereas you're seeing courts in the whole rest of the country, Louisiana, Texas, Michigan, Tennessee, Northern New York, which is much more blue collar and politically mixed, all rule against the vaccine mandates in the religious accommodation context. And I don't think that's probably a coincidence. So that's where the Supreme Court's probably going to have to step in, because there's probably going to start to be more splits. Courts that believe in the vaccine cult, and that's their only God, that's their only deity. I mean, I even had a Twitter feed commentary just to see people's reactions to cognitive dissonance about certain issues, and it was fascinating the explanations people came up with. I mean, it was just it was like, wow, this is like Babylon Bee territory.
Well, the cognitive dissonance, and I don't want to spoil too many of the surprises in the vlog on the Canadian Artur Pawlowski's judgment, which reads a lot like the New York one. But Artur Pawlowski, for anybody who doesn't know, is a Polish immigrant who was persecuted in Poland under communist regime, coming here using the Yahtzee word. And in the judgment, the judge says, someone like you who came from Poland surely should know how inappropriate this comparison is. And I was like, I don't know if that's cognitive dissonance or like, motivated reasoning, where like someone who has more experience than you, who came from it, who can identify it probably better than you can, when they identified it, surely they must be wrong and you're right. So there's no way to get around it. If they agree with you, they're right. And if they disagree with you, they should know better. But in this case, I mean, now that I think about it, there was no plenary hearing, which means no full hearing. So this judge is repeating, I don't want to say spouting off because that would be disrespectful, but rather he's regurgitating or repeating certain claims in science for which no evidence could possibly have been adduced during that hearing. So it's straight up what this judge thinks is judicial knowledge of the realities of what he was describing. And if anyone hasn't seen that video, I thought it'd be of more interest. But what the judge was saying was like, I won't say over the top, was just these are disputed facts even among scientists. And the judge was saying the risk that an unvaccinated parent poses to their child cannot be understated. Cannot be overstated. Sorry, the exact other way.
No.
And what this judge was saying, no, I asked, the question, but there was no scientific expertise provided during this hearing, right, Robert? It's just
there was no hearing. The court denied a hearing, even though the court said, other courts like me have been disciplined for not granting hearings. I'm still not going to grant a hearing because this is so universally it's so universally recognized. The court was too scared to have a hearing. What was the court afraid to hear? What evidence was the court not wanting to have admitted in the record?
It's been a year. It became such an urgency after the guardian ad litem and the wife brought it up. It became such an emergency. They had to. Some people were saying the father had supervised visitation, which is true. Even by the judgment, the father had apparently substance abuse and mental health issues. But those were not the reasons for which he was denied access. It was because he refused to get vaccinated. It was such a dire emergency. They could not wait for a plenary hearing. But no, I was just saying, like, so
especially for people that don't know, you have a constitutional fundamental right to custody over your child, and that can only be interfered with by a court if they find clear and convincing evidence that a particular form of conduct poses an imminent risk. Now, as noteworthy, this court completely failed to cite the constitutional standards applicable to their judgment, which that's no surprise. First time I was in a family court was in Tennessee. And a lot of these family courts didn't work the way they thought they would. They became mills that favored a certain group of people and did not actually enhance people's experience in the judicial system. It was mostly because circuit court judges didn't want to deal with it, hated family law, for good cause. But but what this court was supposed to have found, the first time I was in Tennessee, I raised the Constitution the very first time as a kid lawyer I ever appeared in that court. And I'll never forget the judge. Judge looked at me and was, Constitution? What is that? Well, we're in family court, Mr. Barnes. I thought I was, in that skit where they do the badges. We don't need no stinking badges. It was that kind of routine. And so it doesn't surprise. And again, I've sued judges in New York, family court judges in New York, because of how nuts they tend to be and how they run roughshod. Other government lawyers in other states will shop their cases there's a lot of ways you can do this in the child support context, particularly to New York family court, because it has such a reputation of being so egregious at violating people's civil rights and civil liberties. And they've never fixed it. People think of New York as the sophisticated city. Its legal system is backwards. But what this judge said there's no factual basis for that conclusion that an unvaccinated adult poses an imminent risk of irremediable severe harm to a child. That's ludicrous.
I mean, it's not, and not giving medical advice. It is statistically, by all accounts, ludicrous. It's not me saying this; it's the statistics. And he said, what was the word he used? Oh yeah, the risk cannot be understated. An immediate harm, such that the father is hitherto pending a plenary hearing. But the issue is this: you read it, you know the judge had it in for the father. And this all would have happened in the dead of night, in the darkness of justice. Nobody would have known about it. Now, at the very least, the judgment gets out there. People are asking, other than waiting for the next election cycle, this guy might not get elected out because some people might like it a little too much what he did. This might please people's concerns in New York to the point where he'll get reelected. Is there no supervising body? Because I do remember once upon a time in Quebec, there was one judge who was so over the top, they were recommended by their overarching authority figures to follow some classes, which they did, but they were still judges. They just had to go take some seminars. Can anybody do anything for this judge, or is it not even going to catch the attention of people with greater power than him in the court system?
I mean, only the higher courts in New York can, you can take it up on emergency relief, but nothing beyond that. And the practical reality is that that bias is shared by a lot of judges because it's a professional class prejudice. They all believe in all this stuff. That's why you have the Washington State Supreme Court that's supposed to rule on the legality of vaccine mandates, mandating vaccines for their own employees. I mean, that's a direct conflict of interest. Every single one of them should be recused. But then who's the substitute? It's a flaw within the system. So and the same thing is present here. What I've been telling everybody is the prejudice on this issue is a political class prejudice of the professional class. It's not about law. It's not about facts, because they don't even go through the process. Like, this is a classic example. If you believe you're right about those facts, if the judge really was confident in them, then of course you hold a hearing. And you have a hearing where the other side really gets to present in the adversarial process other evidence that clearly this judge has not heard. But what it is this judge didn't want to hear it. It's a see no evil, hear no evil, know no evil defense.
And they feel so, I mean, he must feel so benevolent and morally righteous while he does it. It's
denying a kid direct access to their parent, because that's what, it's in your best interest that you not be allowed to see your father.
And he says in the judgment,
pontificating nonsense.
No, the judge says the father purports to love his child more than his being, but he doesn't do what every other parent in the school system did: get vaccinated. And then he says, but he'll still benefit from free digital connection, phone and internet. I mean, it's atrocious. Hopefully it gets appealed. We'll see. If anybody's following that, because I don't have as direct access, send me these things. David at vivafry.com. It's loaded with spam, but I still get some messages make its way through.
So far, the court of public opinion is what's worked. Because remember, there was a Chicago court that did the same thing. No, there was so much blowback in the court of public opinion, the court suddenly reversed itself sua sponte.
Yeah,
now, this is New York, so we'll see.
Well, that's it. In that case, the judge rescinded his own order without being, told to do so. My big concern is always, public pressure backlash can sometimes turn into harassment and doxing, and there's the fine line between
harass or anything else. People should condemn it in the court of public opinion, never directly reach out to the court. Condemn it in the court of public opinion and say why it's wrong.
Anyway, get it in the news. I mean, it's been in the news, so hopefully there'll be some reaction. Let me bring this chat up because it's massive, and I have to bring it. It's going to take up my face. Woggett says, "Hey fellas, my wife is attending a public nursing program. They will have a religious exemption. However, the participants are required to work in private clinics around the community, and if any of the clinics deny a religious exemption, she will be expelled. Discrimination by proxy."
Yeah, that's still a form of religious discrimination, and many of these laws apply to public accommodations as well. So I mean, I think ultimately the only case that's gone against religious accommodations has been Maine. Not a surprise. Reminded me of I was in front of some of those Maine judges on election issues during the pandemic. And the only consistency I found in the federal courts in Maine was deference to whatever the Democratic governor wanted. It reminded me of the old, when Huey Long and Earl Long were having a dispute in Louisiana. Huey Long had put in one of his people as governor of the state while he was senator. And so the joke was that this guy, OK Allen, was just doing whatever Huey Long told him. And the way Earl Long told the story, he said, a leaf once blew across OK's desk and he signed it. Well, the judges in Maine seem to have taken the same approach of deference, undue deference to the state authorities in Maine. To say you have no right of any religious accommodation under the First Amendment to the U.S. Constitution or under the relevant state or federal laws is just an outrageous decision and the first of its kind. And so I think, if any case should be taken it's a compelling case for the U.S. Supreme Court to take. The only thing I would say is I think these cases are stronger if people emphasize that their clients are, like my clients in the Tyson Foods case, are being forced to make a choice between the vaccine and their livelihoods, between their conscience and their livelihoods, between their bodily autonomy and their livelihoods. And because that focuses on the part of why do we need injunctive relief? Why can't back pay and monetary relief cover it? It's because you can't get back the violation of your conscience. You can't get back the violation of your bodily autonomy. That's gone. That's why we always say constitutional violations are irremedial. I can't ever say that word. That's it. Irreparable. Yeah, irreparable is better. Irremedial is whatever. Irreparable injury. And that's why. And so I think if more people focus on that, that will be better at getting the court's attention, because it was that focus which helped in the United case. That focus partially helped in the Tennessee case. There's some more cases being brought. There was a Navy SEALs have filed suit this weekend in the Middle District of Florida, I think on Friday, against the Defense Department. Case brought by the Liberty Council, which people can look them up. They're doing a lot of great work on this out of Florida. And they challenge it because the Biden administration apparently is floating the idea that if any Navy SEAL would rather resign than take the shot, that they are going to sue that Navy SEAL for the economic cost of training them over there, basically bankrupt that Navy SEAL. So it's not just good enough to deprive someone of a passion and a career and a profession that they've dedicated and risked their lives for. Now they're going to bankrupt them as well if they assert their conscience. This is getting to when I told this to somebody else, they said, "Oh, I remember that. That used to be an old Soviet technique." That's where we are right now in this country,
Robert. And you have it's just. I have no words because it's very it really is depressing. You try to not get angry, but you see influential, otherwise reasonable people now thinking it's acceptable to say, don't deny services to the unvaccinated. To say things that they're fundamentally inhumane, but it's now become mainstream. And I don't know who steps it back. I don't know who brings it back. I don't know who talks everyone down. And the people with influence, it's not like fringe elements saying, hey, overweight people really should be denied access to hospitals, or they should be made to pay their own costs to the extent that, they did this to themselves. It's not there. It is just on this one political issue, which is being weaponized against a minority of individuals in the absence of compelling justification. And I don't know how it steps back, because it just seems to be, hurtling forward full throttle. No, go after them to recoup your costs for training because something changed. Even call it force majeure. Now you say either do this on a going forward basis, or we're going to unilaterally, arbitrarily, and retroactively claim damages for what we did. Not. This is how you drive people.
And these are Navy SEALs.
Yeah,
these are people who take the greatest risk to defend the country. That's who they're treating. It's extraordinary. The same people that this president abandoned, some of whom he abandoned in Afghanistan to their deaths because of his incompetency and dereliction of duty. So it's striking. It's which may be a transition to our next topic. The plea disposition reached by the soldier who spoke up about the many derelictions of duty taking place in the military these days.
Taking for granted everybody knows about this, Lieutenant Colonel Stuart Scheller, who was jailed, briefly released for having posted social media posts critical of the government and the military for their withdrawal from Afghanistan, was told not to post any more videos. Some gag order was issued. He nonetheless continued to do it. And we've seen, even among our ardent followers, Robert, supporters, people who like us, there's been a pretty decent split. Some saying you go to the military, you know what you're signing up for, you abandon your First Amendment rights. Others saying you can't have whistleblowers in the military if this is what the precedent is set. So all that set aside, he was arrested after one of his repeated violations, sent to the brig, briefly released. What's the sanction, Robert?
So he cut a deal. And so he pled guilty to all those charges, unbecoming an officer, all that jazz. So
Insubordination or whatever.
yeah,
it was.
insubordination, contempt, disobeying, etc. And my view was he had a robust First Amendment defense, because my view is that the First Amendment limits the military's ability to discipline to those cases where your speech they can show directly incites officers to not function as a military unit. And it can't be criticism of higher up people for making mistakes that need to be commented upon and talked about to remedy. What he was requesting was relief and remedy that would improve the efficacy of the military, in my view. So I thought he had a robust First Amendment defense. But what they did is they offered him a deal where the whole penalty is just in the press release. Because while they say, look at all these things he pled guilty to, what they did not highlight, the Washington Post and other media institutions that covered it didn't highlight, is he serves no time at all. He gets an honorable discharge. He only loses about 2/3 of his pay for 1 year. He already knew he forfeited his pension once he made his statements, because he knew he was out on those grounds. And given the amount of money raised for his defense, right now, if you're out there in the military, look at what happened to him. He became much better off financially for speaking his mind than if he'd kept his mouth shut.
So just to clarify the terms then, so the honorable discharge does not reinstate his pension. So he gets
an
an
honorable pension is 20 years. That's the pension he doesn't, but it'll still qualify for all the other veterans benefits. So all he loses is 2/3 pay for 1 year. That's it. And otherwise, and he gets an honorable, and he was already going to be discharged, so he wasn't going to be able to get a 20-year pension because he wouldn't be in the military for 20 years.
Well, so but he
even
lost
an honorable discharge, not even a dishonorable discharge.
But he did lose whatever pension he would have been entitled to had he made it to 20 years, but he still gets benefits.
Correct. It's mostly meant to be a scary example, but if you look at the actual consequences, it shouldn't be. For if you're out there in the military and you see this, it shows the military is scared of a First Amendment challenge, a robust First Amendment challenge. They don't want to fight it. But this guy had raised so much money, over $2 million for a legal defense fund that would otherwise go to him. By the way, Lynn Wood, by the way, certain other lawyers, this is how you're supposed to behave. You're not supposed to demand somebody's legal defense fund for yourself, just FYI. That the money would go over, it now goes to him personally, but because they saw, oh, wow, this guy's got $2.5 million legal defense fund. He's going to have a bunch of lawyers line up that make creative First Amendment arguments. We're probably wrong on our First Amendment violations of our soldiers. We don't want to risk that. We'll let him walk and actually become better off financially than he would have been had he kept his mouth shut.
I guess it's good. On paper, it will still be fearful. It'll still be fear-inducing, rather, to others who might speak up.
Yeah, but what it shows is the military is much more scared of a First Amendment challenge than they've been willing to let on, because they would have never let him walk on such a soft deal, but for their fear. What it shows you is when there's crowdfunding for good lawyers combined with smart legal defenses, the institutions get scared real fast.
Well, and I was going to say that this illustrates the beauty of crowdfunding, because when you have a good case and a sympathetic cause and you're a just cause with an honest individual, you can easily raise it. And then, hopefully you're not who were the people that screwed the homeless guy with the last $20 for gas? Oh, forget their names. But the first time we got wise to how GoFundMe can be used to defraud. But if you're a good person with a good case, it's an amazing way to go about doing things. You really don't have to worry about finding and funding the legal fees. You can get people who want to rally behind you and do it. So it is good. Good for him, yes. And he got the message out and got the discussion out, which is probably more important than anything.
Oh, absolutely. And it also shows he's right. They definitely didn't want a discovery process and other things that might go in directions they didn't want it to go in. So it shows that they're much guiltier than they want to let on. They got the PR release that they needed to intimidate the soldier that doesn't look past the headline. But for the military member that looks past the headline, they realize that the system is a lot more scared of them than they think it is.
I'm going to bring this one up. I always hate the argument that something can suppress the rights or are above the Constitution. Leftists argue that business can do what they want. can they enslave trade or U.S. Essentially, they're arguing, well, it might be a bit of a straw man because they're going to say that they're private enterprises. They don't have to respect the Constitution, but they have to respect the law. But some of these private enterprises, um, arguably above the Constitution, given what they're given their roles in society.